Judith Ritter, you're Mumia Abu-Jamal's lawyer. You're in Paris. Why are you here?
I'm here because yesterday was the 5th anniversary of dedicating a street in Saint-Denis in honor of Mumia. So I was here for the celebration of that event and to explain to all of his supporters over here about the status of the case and especially about the court decision that came down just a few days before I got here.
Mm-hmm. It's probably the only street that has that name. How does Mumia feel about it?
He's very honored, really. He's very honored. He's very, very grateful. He has so much support, and it means an enormous amount to him. So he's very grateful.
So you're basically here to explain what happened the last few weeks. Could you explain it, because it's rather complicated?
It is complicated. A big reason for it being so complicated is that the law in the U.S. about challenging convictions has gotten so complicated even for the lawyers in the U.S.
In order to refrain people from doing so?
Well, yes, because the Congress, the U.S. Congress, at least those who were in control when the current law was passed, very much wanted what they call finality, which is that they want the executions to happen sooner than they were happening. Mm-hmm. And they want the challenges to convictions to be stopped sooner than they were being stopped, and that the challenges couldn't go on, even when the challenges were bringing up real claims about constitutional violations that were actually winning in federal court. That was the basis for wanting to restrict the ability to get into federal court on these claims. But I can explain what happened last week, and I guess I'll go back a little bit to remind you that in 2001, a federal court judge, Judge Yan, made a decision after hearing a federal petition. Of course, Mumia was convicted in the state of Pennsylvania, in a Pennsylvania state court. But after years of challenging that conviction, a petition was filed. This was by prior counsel. A petition was filed in federal court with, I think it was 29 or 30 claims with regard to constitutional violations at the trial, the guilt or innocence phase,
because
and
he tried,
the sentence phase.
Because he tried before in Pennsylvania, as you said. I was there in, I think, 2005 with the post-conviction relief.
That was 1995.
1990. My
yes.
God. it was. Yes.
Same thing happens.
And then he had the same Judge Sabo who basically convicted him in the first place.
Yes. Now, of course, they'd say the jury convicted him, but Judge Sabo was the trial judge sitting on the trial, and who actually imposed sentence after the jury jury found for death. And yes, you're right.
So there was no point in trying more in Philadelphia or in Pennsylvania itself.
Well, we did try. In fact, there's still, right now, there's a post-conviction petition pending in state court in Pennsylvania currently. There was the 4th petition filed, and it was denied, and it's being heard. The Supreme Court of Pennsylvania is deciding. But we have not gotten any relief from any of the state courts in Pennsylvania. So, but there is a provision in law for a federal, they call it habeas corpus petition, that was filed. And decided in 2001, and out of 30 claims, there was only one claim that Mumia prevailed on, and that claim was with regard to the penalty trial. We call it the penalty phase, but it's a penalty trial. And the claim had to do with the fact that the jury instructions were wrong, and that they were unconstitutionally gave the jury the wrong impression about how to go about deciding between life and death. And we won on that claim. All the other claims with regard to everything from jury selection and race discrimination to ineffective assistance of his trial counsel to witness intimidation, on, were all denied.
Which were nevertheless established out of court, because I saw some of the witnesses, I read the files.
There was a hearing in state court, which is what you were talking about before, post-conviction, 1995, before Judge Sabo. They were litigated there. It's not easy to get another hearing with evidence and witnesses in federal court, so that did not happen in federal court, because the law is very, very restrictive on that. But the legal arguments, based on what the state court record, what the witnesses said in state court, the legal arguments based upon that were rejected by the federal court. We got permission to appeal 3 of those issues only out of 29 or 30. We got a permission to appeal 3. The prosecutor appealed the one we won on, and those 4 issues went to the Federal Court of Appeals. There's a level of federal appeals in between the trial court and the U.S. Supreme Court. Is called the Circuit Courts of Appeal, and for Pennsylvania, it's the Third Circuit. So we appealed, and the appeals were filed and argued in May 2007. And after they were heard and decided, the court ruled against us on our 3 issues and said the lower court was right to deny them. And the one that we had won on in the lower court, they upheld that win and said, yes, the death penalty was unconstitutional in this case because of the jury instructions. What happened next was that the district attorney, the prosecutor, asked the U.S. Supreme Court for permission to hear that case that they lost. We asked for permission to go to the U.S. Supreme Court on the ones we lost on. And you may or may not know the U.S. Supreme Court, it's called a petition for certiorari. They grant very, very few of them. The ones that we were asking about, they denied review, I think a matter of weeks, very quickly. The one that the prosecutor asked for permission to review, they waited and waited, and then what happened while they were waiting on that, just hadn't decided it, is they decided a case coming from the state of Ohio. A different case, of course, different defendant. Actually a really horrible case. The defendant was a neo-Nazi who had been sentenced to death and who had raised an issue similar to our issue about jury instructions. And they took that case, the U.S. Supreme Court ruled against him. And what the U.S. Supreme Court then said was, took Mumia's case and said, we don't want to decide yet so much whether we're going to review it, but we're going to send it back to you, Third Circuit Appeals Court. Now that we've decided this other case called Spizak, look at it again. So you change your mind now about Mumia's case? And so we went and filed briefs on that, and that's what I argued this past November as to whether the new case from Ohio made any difference. And the truth is that the law really was very good for us in terms of the case law. It was a very different case. I mean, I'm a lawyer, and I always will argue, of course, for my side, but the law was really on our side, too. I was confident, really, that we were right on the law and that the Third Circuit should not change their minds just because our case was so different. Even if you agreed with the Supreme Court in that Spizak case, our case was so different, so much worse in terms of constitutional violations. And so just on Tuesday, April 26th, the Third Circuit ruled that they were not changing their mind, and they wrote a long opinion, I think it was 20, 30 pages, about how that case was very different from our case, which is just what we were claiming. That day, that very same day, the district attorney, the prosecutor, held a press conference just later that afternoon and announced that they had called the widow of Officer Faulkner.
That's the officer who was shot.
That's right. And to ask her whether she wanted them to appeal what just happened. And she said she did.
Does she have a point in it?
Well, no, only if the district attorney chooses to give her that influence. And so what he said, and I did not see the whole press conference, but the part that I heard was that he said that he would need to read the opinion more closely than he had read it yet, but that he was inclined to ask the Supreme Court to review it.
But it doesn't sound very strong on his part.
It doesn't. But he has 3 months to make up his mind about asking the Supreme Court to review the case. And then then he can ask for more time to decide. But in about 4 months, he'll have to make up his mind. Does he ask the U.S. Supreme Court to take the case? If he does ask them to take the case, we will oppose that. And the Supreme Court may or may not agree to review what the Third Circuit just did last week. If they do not ask the Supreme Court to review, or if the Supreme Court says, no, we won't review, then again they have to make a choice. And I think, it's important to know that it's their choice to put together another penalty trial to try to get the death penalty imposed again against Mumia. Or
ask for a different penalty.
They wouldn't have to ask for a different penalty if they just do nothing. No, I'm saying if they do nothing, It's automatically a life in prison sentence without the chance of parole. That would be automatic.
So in all practicality, Mumia Abu-Jamal is still on death row?
He is still on death row, not in all practicality. He literally is still on death row. And that's very significant. It's not just a term. When you're on death row, you are essentially in a cell 23 out of 24 hours a day. You don't have contact visits with family or anybody or lawyers. And that on and on and on. There are so many restrictions. Look, everybody in prison has a lot of restrictions, but on death row is much more. And that hasn't changed. You know, the death penalty was set aside in 2001, and he hasn't set foot off death row. So yes, that's still the case.
And he's been in prison since 1981.
Correct.
Which is basically more than I think any people in Europe would go to prison for any crime.
Well, you probably know that better than I do, but I think you're right.
Because that's more than half of his lifetime.
It is.
He turned 57?
Yes, 57, 58, I thought. I don't know. You know, I have to do the math again. But yes, his birthday was last week. And, right, more than half his life, regardless.
And how is he personally? How is he doing?
He's very busy. He's very busy, and thank goodness, because his mind is still very sharp. I talk to him on the telephone, and I see him as often as possible. His mind is good and sharp, and somebody commented yesterday at the event. He doesn't like to talk about himself.
No, he doesn't do so in the radio.
About himself, I'm saying. No, I talk about himself. No, I don't want to say that I hear everything he says on the radio, on these commentaries. They're all about politics and the state of the world and war and racism and poverty.
My name is Mumia Abu-Jamal. I'm on death row in Pennsylvania. Ex-president of the Association of Black Journalists in Philadelphia. I'm still a continuing revolutionary journalist. I write for anybody who wants me to write for them. And I'm fighting my conviction, fighting the sentence, fighting for my life, and fighting to create revolution in America.
Homeland and hip-hop. To think about the origins of hip-hop in this culture, and also about homeland security, is to see that there are, at the very least, two worlds in America. One of the well-to-do, and another of the struggling. For if ever there was the absence of homeland security, it is seen in the gritty roots of hip-hop. For the music arises from a generation that feels, with some justice, that they have been betrayed by those who came before them. That they are, at best, tolerated in schools, feared on the streets, and almost inevitably destined for the hellholes of prison. They grew up hungry, hated, and unloved. And this is the psychic fuel that generates the anger that seems endemic in much of the music and poetry. One senses very little hope above the personal goals of wealth to climb above the pit of poverty. In the broader society, the opposite is true. For here, more than any other place on earth, wealth is so widespread and so bountiful that what passes for the middle class in America could pass for the upper class in most of the rest of the world. Their very opulence and relative wealth makes them insecure, and homeland security is a governmental phrase that is as oxymoronic, as crazy as, say, military intelligence or the U.S. Department of Justice. They're just words that have very little relationship to reality. Now, do you feel safer now? Do you think you will anytime soon? Do you think duct tape and Kleenex and color codes will make you safer? From death row, this is Mumia Abu-Jamal.